Chapter 18, the Law of Administrative Agencies, talks about administrative law as any rule that directly or indirectly affects an administrative agency. Procedural rule, a rule that governs the internal processes of an administrative agency. Substantive rule, a rule that creates, defines, or regulates the legal rights of administrative agencies and the parties that they regulate. Administrative agency, any body that is created by the legislative branch to carry out specific duties. Independent administrative agency, an agency whose appointed heads and members serve for fixed terms and cannot be removed by the president except for reasons defined by Congress. Executive administrative agency, an agency located within a department of the executive branch of government. Heads and appointed members serve at the pleasure of the president. Enabling legislation, a legislation that grants lawful power to an administrative agency to issue rules, investigate potential violations of rules or statutes, and adjudicate disputes. Legislative power, the power delegated by Congress to an administrative agency to make rules that must be adhered to by individuals and businesses regulated by the agency. These rules have the force of law. Executive power, the power delegated by Congress to an administrative agency to investigate whether the rules enacted by the agency have been properly followed by businesses and individuals. Judicial power, the power delegated by Congress to an administrative agency through an administrative proceeding, includes the power to issue a complaint, have a hearing held by an administrative law judge, and issue either an initial decision or a recommended decision to the head or heads of an agency. Administrative Procedure Act, or the APA, is law that establishes the standards and procedures that federal administrative agencies must follow in their rulemaking. Consent order, an agreement by a business to stop an activity that an administrative agency alleges to be unlawful and to accept the remedy the agency imposes. No admission of guilt is necessary. Administrative law judge, or an ALJ, is defined as a judge selected on the basis of a merit exam who is assigned to a specific administrative agency. Preponderance of the evidence, a legal standard whereby a bare majority or 51% of the evidence is sufficient to justify a ruling. Also discuss limitations on administrative agency powers and discuss the statutory limitations along with there are institutional limitations. Excuse me. Chapter 19 was about the employment relationship and immigration laws. Wage and hour laws. Employers no longer have complete freedom to pay workers and wages they choose or to require them to work any number of hours. Federal laws impose minimum wage and hour requirements. The FLSA, which is a Fair Labor Standards Act, covers all employees in covered industries. Wages are based on cost of living and whether or not you earn tips. That's factored in. Unemployment compensation. Federal Unemployment Tax Act provides compensation to qualified employees who lose their jobs. Employers pay their taxes to the states, and then those tax dollars are deposited into the federal government's unemployment insurance fund. So then each state has an account from which to access the money in the fund for when you file for unemployment. Cases of filing for unemployment, we are currently going through that with the pandemic of the coronavirus. They have agreed, I know in the state of Ohio, that anyone that is employed and is not considered an essential employee that is not working right now because of the pandemic and the stay-at-home order, you can file for unemployment. There's usually like a 3-week period, a 1-week waiting period, and then you have to wait 2 weeks to get paid. But they've waived that 1-week pay period, that 1-week waiting period, I'm sorry. And then they're hoping to get the funds to you before 3 weeks pass. I know that, I don't know the numbers the other day, it was like 3.1 million people or something, which I'm sure it just continues to grow, have been filing for unemployment. And it's becoming so large that the sites are crashing. They're having problems logging in and filing for that unemployment. But it is something that definitely is needed right now, of course, with not being able to work with the coronavirus, and the bills are still there. So if it's not, going on right now with the pandemic and the coronavirus, yes, you can file for unemployment if you're no longer employed by that company, as long as you are let go. If you quit, you don't qualify for unemployment. But if you're let go by the company or the company closes down, it really depends on the circumstances. As you can tell, I have a lot of experience with this because I have had, life experience with unemployment. My last employer, the company actually closed after being open. I think they were open for 7 years, and I was an employee for 5.5 of that. So because they closed, it wasn't that I quit my job or I was let go. I did qualify for unemployment, which I was very thankful for, because that, losing my job with no warning was pretty scary. Workers' compensation laws are state laws that provide financial compensation to covered employees or their dependents when employees are injured on the job. I have familiarity with that as well. Not a personal experience as me personally, but my mom got hurt on the job. She was working at a factory and she got hurt there, and she did file workers' comp. And I do remember excuse me, that it took a lot to get it to go through. And once, she finally was able to prove, per se, through the doctors and everyone that had to have a hand in it and see her and make sure that everything was on the up and up, because unfortunately some people abuse different programs like workers' comp. So once they said, yes, we believe you, we know that this is really a workman's comp case, she started receiving benefits from that. So it's not just that simple, oh, I was hurt on the job, I'm getting workman's comp. It doesn't work like that. There's a lot of hoops you got to jump through, metaphorically. FMLA is the Family and Medical Leave Act. It's a law designed to guarantee that workers facing a medical catastrophe or certain specified family responsibilities will be able to take needed time off from work without pay, but without losing medical benefits or their jobs. Violations of the FMLA: if the employer fails to comply, the plaintiff may recover damages for unpaid wages, lost benefits if proven bad faith on employer, because sometimes that happens as well. OSH Act is Occupational Safety and Health Act. It's a regulatory act designed to provide a workplace free from recognized hazards that are likely to cause death or serious harm to employees. Occupational Safety and Health Administration, or OSHA, is the agency responsible under the OSH Act for setting and enforcing standards for occupational health and safety. I have worked in a factory before, so I'm familiar with OSHA. Whenever you go through your orientation and even while you're training on the job, you hear a lot about OSHA, because you have to make sure that you are working safely, or as they say, OSHA will come in and shut us down. You definitely want to have a safe work environment, or that does happen. Occupational Safety and Health Review Commission, or the OSHRC, is an independent body that reviews OSHA citations, penalties, and abatement periods when they are contested by an employer. The National Institute for Occupational Safety and Health, the NIOSH, is a research facility established by the OSH Act to identify occupational health and safety problems, develop controls to prevent occupational accidents and diseases, and disseminate its findings, particularly to OSHA. They also discussed drug testing, which came into effect in 1988, where the employer can test you for certain drugs, and that would be a reason for being let go on the job. Immigration law came into effect in 1986, and they also discussed green cards for the authorized non-citizen workers. So those are all things that have come about in the last, 40 years or so. Different things that have been happening with employment, and as a working professional, I am glad that those options do exist. My current employer, we are not considered essential employees. We are at home as of Monday, per the governor, and I am still receiving my wages through my employer. We are going to be given that through a contract. So since it was a contract that was designed and it was set up throughout the year, that's why that's okay. So that's my take on the chapters, and I hope you enjoyed that.